Hi, my name is Barry Doyle. I'm a lawyer in Chicago. Today I've got a question that I'm going to be answering, and that's what are the deadlines that apply for an Illinois workers' compensation case? There are two deadlines that you got to meet. If you don't meet both of them, you're out of luck. It could cost you thousands of dollars in access to quality medical care. So it's important that you meet both of these deadlines. The information we're going to be sharing in this video today is important for anybody who puts themselves on the line in terms of being at risk of hurting themselves in a dangerous occupation like trucking or anything similar to that. So if you can hit like, hit share so that this information gets circulated in your network, you'd be doing everyone else a big service. So there are two deadlines that you have to meet. You have to meet both of them in Illinois. Now, it's also important to keep in mind that what I'm talking about today applies only in Illinois. Workers' comp is a question of state law, and the procedures that have to be followed in each state, especially the deadlines are different. So it's one of those things you want to check out if you're doing a workers' comp claim in a different state. But in any event, there are two that apply in Illinois. The first of these is what's called the notice requirement, and that's 45 days from the date of your accident. It's not anything that has to be done formally in the sense of submitting a written report or a statement or anything like that. There's nothing that has to be filed. It can be as simple as calling into dispatch and saying, "Hey, I hurt myself." Just letting your employer know in some way that you've been hurt. It's a good idea to keep track of who it is you give that notice to and how you give them that notice. Whether it's I call them on the cell phone, I communicate with them in some other way. But it's important that you know how it is that your employer got that notice within 45 days of the date of injury. It's not such a formal requirement. Most often that's not such a big deal. But there are cases where that certainly comes into issue, and knowing who it is that you gave that notice to is something that's certainly going to help you. Again, 45 days, your employer has to have notice of the claim, and the whole idea is that so that they can put their workers' compensation carrier on prompt notice of the fact that the claim is being made. Because they're going to be responsible for, at a minimum, your medical expenses and any disability payments you get while you're off work, as well as any kind of a settlement you might get in connection with the injury. So the insurance company needs to know in a relatively timely kind of way that there's going to be a claim that's out there. So that's the whole purpose of the 45-day notice requirement. It's not anything that's real formal, but you absolutely have to meet it. If you don't meet it, and the case later becomes a matter where everything is being contested, if you hadn't given your employer notice within that 45-day period, you're out of luck. You're not going to get anything. So, assuming that you've made the 45-day notice requirement, there's a second requirement that has to be made, and that's the statute of limitations. Now, the statute of limitations, there are two different ways of kind of calculating what the statute of limitations is. The first of these would be 3 years from the date of accident. Now, the statute of limitations is something that's much more formal. It requires an actual filing of a piece of paper called an application for adjustment of claim in the organization that adjudicates workers' comp claims in Illinois, which is called the Industrial Commission or Workers' Compensation Commission. That has to be filed within 3 years of the date of the accident. Another way of calculating that is within 2 years of the last receipt of workers' comp benefits, whether it's payment of medical expenses or the disability checks that you get while you're off work. So if you're off work for, let's say, a year and a half, and sometime after that 3-year mark, you go ahead and you actually file an application for adjustment of claim with the Workers' Compensation Commission, you're still going to be within the statute of limitations. A friend of mine talks about that 2 year after last receipt of benefits as being like the reserve parachute when you go skydiving. It's great to have it, but you don't want to find out that it actually works. The best thing for you to do is make sure that you have an actual application for adjustment of claim on file with the Workers' Compensation Commission within that 3-year time window. If you don't meet either of those two ways of calculating your filing date, 3 years from the date of accident or 2 years from the last receipt of benefits, once again, the statute of limitations is going to expire, and you're not going to be able to get any additional benefits, including payment of medical expenses, including any kind of disability payments you might be entitled to receive. So those are the two deadlines that you have to meet. Now, these deadlines become important only when you really let things go in terms of having had an accident and having not really pursued things. And one of the reasons that it makes sense to get quality legal help is that one of the things that lawyers are responsible for is making sure that these deadlines are met and that you don't have problems with either of these two deadlines, the notice requirement or the statute of limitations. So I hope this has been helpful. If you could hit like, hit share so that people within your network can get the benefit of this information. My name is Barry Doyle. I'm happy to help. You can reach me through the website, www.Rights of Injured Truckers, through the Facebook page, or you can simply call our office at 312-263-1080. Hope this has been helpful. Have a great day.